Okay, so it looks like everybody's kind of connected to audio who's here, and my colleague Ellie is going to be watching the waiting room, so that if anybody else, if we have any late arrivals, we can let them in as we commence. So hello everybody, thank you for joining us. I don't know if any of you were on the previous one, but if not, I'll just let you know my name's Catherine and I'm going to be hosting it today. And basically what we're going to do, which we found is a really good format, is we are going to address the most frequently asked questions that we have from the BII members for the main, because we're the employment law firm that deals with your BII inquiries. So I'm sure a lot of you may have spoken to me if you've used BII. I apologise if you have. I hope I gave you worthy advice. So what I'm going to do is I am going to start sharing the presentation and we'll get started. And then if anybody else comes in, I'm sure they'll pick it up. As with the last one, for those of you who weren't on the last one, if you do have any questions, we are more than happy to answer questions. But obviously in this format, it's a little bit difficult. So if you bring up your chat function for in the Zoom, any questions you've got, whether it's anything that you want clarification on with anything I'm discussing, or if you've got any additional questions, pop them in the chat and my lovely colleague Ellie is going to be collating them during the presentation. And then at the end of it, we'll pick up any of those questions that you might have. And we are going to be, we haven't got the date yet because we're still confirming that with Molly. Hi, Molly. But we are going to be doing another one of these. And the focus of that is going to be sort of post April the 12th, because I'm assuming a lot of you are going to be gearing up to open now on April the 12th. And that first kind of week of trade is probably going to throw up some crazy things to do with employment, people not wanting to come back from furlough, etc. So we will be doing another one kind of sort of thinking about having brought people back, anything that's come up in that respect, but we will have to confirm that date with you. I know my colleague and Molly are just talking about that now. So let me share my screen and we will get started. Where is it? Share screen. There you are. So my name's Catherine and I'm Senior HR Advisor within Biani HR and Employment Law. And as I just said, we're the people who deal with your employment and HR inquiries on the BII helpline. We're an independent law firm. We do a vast array of lots of different things, all of which are employment related, whether it's performance, whether it's disciplinary, whether it's discrimination, whether it's actually running tribunal claims, both for the claimants and the respondents. We do anything you can think about to do with employment. And we also have a retainer package as well, which is separate to the BII for our clients. And that's, you know, it's a cost-effective way of getting quite in-depth and dedicated advice. So let's get started. The first few things are not actually frequently asked questions. It's more to do with the dreaded April, where things always change when it comes to rates. So it's just a few things that you need to think about. And you'll see that I've put some tables on, but don't worry about actually taking that information. What I would recommend is that you go to gov.uk, because I basically pulled all of these tables from gov.uk and all of your new rates are laid out on there. So national minimum wage, you need to be thinking about that. That increased from the 1st of April. So you should have already implemented those increases. One thing as a watch out is the national living wage. The age for it has actually been lowered. So whereas previously the national living wage only kicked in at the age of 25, now it kicks in at the age of 23. So you just need to go back to your kind of your staff lists, work out who that applies to, and make sure that the living wage is applied to them rather than the previous one. And the other thing with that as well, furlough, actually, yeah, I'll mention that. So with regard to furlough, especially as probably as of next week, you're going to have lots of people on flexible furlough. It's important to remember that furlough, when they are furloughed and not working, is based on the historic payments that you've been basing it on. So the minimum wage increase will have no bearing on the actual furlough payments. But for any hours that they are working for you, the national minimum wage will apply to that. Okay, so just that's a watch out for you. And if any of your staff come to you complaining that they felt that their furlough payment should be increased in line, you don't have to do that. It's all based on historic payments. So statutory sick pay has gone up. So From the 6th of April, so from yesterday, it's risen up to £96.35. So it's important that any employees who are currently on statutory sick receive this increase as well, including those who are on sick because of the coronavirus. That's indeed if they remain eligible. And whilst the same fixed weekly rate applies to all employees, you do also need to bear in mind that it does get prorated down in terms of the amount of days that they work for you. Again, this table is on gov.uk and it's quite a handy table. And there are also on gov.uk for all of your statutory payments, there are payment calculators. So whether that's redundancy or sick pay, there's some really, really good tools on gov.uk to help you to calculate those things if you don't have an accountant to do it for you. Statutory payments. So when we think about statutory payments, that's things like maternity, paternity, adoption, shared parental pay and shared parental bereavement pay. And that has increased from £151.20 to £151.97. So I'm sure that 77 pence increase is going to have a massive impact on your employees. And if you have, again, an employee currently receiving statutory payment, it will need to be increased. Okay. And then statutory redundancy pay. So this isn't the notice pay, this is the redundancy pay, which is sort of separate to notice. So the statutory redundancy cap has increased from 538 to 544. And it's not applicable to people who have already been made redundant prior to the 6th of April. Only people who are either still within their notice period or still within the redundancy process. So basically what that means is if they've already left the business, if they've already been terminated, even if it was on the 5th of April, the 538 will apply. Anything where the termination happens after the 6th of April or inclusive of the 6th, then the 544 will apply. But anything you're not sure about, if you've got accountants, then they really ought to know the answers to these questions. And also you can always give the BII a quick call, the helpline, and we'll be able to help you with that. And then IR 35. Now, technically, this isn't actually employment because it's to do with self-employment. However, as employers, you do need to be aware of it. And it sounds a lot more it sounds kind of more complicated than it is. Basically, if it doesn't affect you, you don't need to worry about it. And it's relatively easy to determine whether it does affect you or not. If it does affect you, then there are some hoops that you need to jump through. So it's term used for tax legislation, which is why nobody likes it. And it's designed to make sure that those who are self-employed but do work through their own company are paying the correct amount of tax. The reason this has come about is really because there was a bit of a loophole that people could use where they were technically an employee because they were working there, but because they were doing it through their own company, then it meant that they could kind of pay less tax. And it's just that loophole is being closed. So as an employer or business, you need to look at your staffing. So if all of your staff go through your payroll and you pay them, and then you also take into account and pay their national insurance, their tax, etc., you don't need to worry about this at all. If you use any agency staff or any self-employed people, that's when you might need to put some thought into this. So you need to be asking them, do they operate through their own company, or do they just invoice you as a self-employed person? If they just invoice as a self-employed person, it's fine. If they do it through a company, then IR 35 is likely to apply. So the government have a free online tool, which is on gov.uk, which is basically like they ask you a series of questions and you tick yes, no, or whatever the answer is. And then at the end of it, it'll tell you whether or not IR 35 applies in principle. If you find that a contractor or worker does fall within IR 35, then you may be responsible for the PAYE, or it will move along the chain if you've engaged a contractor or worker through an agency. And putting a contractor on PAYE does not automatically make them an employee. It could be that they're a worker, but we would massively, massively recommend that if you've got anybody that you think falls into this category, you get advice on employment status, because it could really come back and bite you on the bum if you don't do that properly. Okay, but like I said, if the only people you engage with in your business go through your own PAYE and you pay their tax and national insurance, you don't need to worry about this at all. So moving on to the frequently asked questions, which are really some that we've had this week. So an employee wants to amend their hours as they have a new job. Do I have to accommodate this? Since everybody's now considering opening next week and lots of people are being informed they're off furlough, we must have had, Ellie and I, just on this question in the last week or so, at least 20, 25 queries about this. Because obviously, whilst people were on furlough, whilst they couldn't work for you, they could actually work for somebody else. And a lot of the employees were not being upfront about that. Ethically and morally, whether it was the right thing to do is questionable from the employee point of view, but technically they could do that. So the short answer to this is no, you don't have to. So if they come to you and say, oh, well, I can't do those shifts now because I've now got this job elsewhere and I want both jobs, you're under no obligation to amend their hours so that they can have that other job as well. It might be worth considering. So legally, you probably don't need to. You would need to document a reason why you said no, but legally, you're not really on shaky ground because they're not asking for something to do with them, like a disability or something. It's because they want a second job. So it's very low risk to say no to it. From a running your business point of view, however, it might be worth considering because obviously when you reopen on the 12th, which, hopefully you're all going to be busy, then there is a good chance that you're going to be on reduced trade due to the restrictions that are in place because, at first you're not going to have your inside open, only your outside. So that's less customers that you can serve. So it means that there's going to be less hours to go around for your staff. So if they're coming to you saying you want to amend their hours, what I would potentially be saying is, well, I can't amend it so that you've still got the same amount of hours, for instance, but what I can do is reduce your contracted hours. So if you've got somebody who's on, for instance, a 30-hour-a-week contract, you can say, well, I can't just give you 30 hours a week around your new job, that I can reduce it to 10 hours. And the beauty of that is it means that you've then got less hours to find for your staff. And also, from a flexible furlough point of view, it may be that you only need to honour those 10 hours. So, they're going to be getting less money, which means that they're potentially going to think about either moving on or quitting the second job. Either way, but it puts the ball in your court more. So it might be worth considering doing it. Like I said, not reallocating all of their hours around, but saying, yeah, okay, we'll do a reduction. And like I said, they don't have the right to demand it. They could put in a flexible working request, which is a more formal way of doing it. They have the statutory right, if they work for you for more than 26 weeks, to make a flexible working request. About anything to do with their hours or their home working, for instance, things like that. Just because it's a statutory right for them to put that in, it doesn't mean it's a statutory right for it to be accepted. But if they do formalise it as a flexible working request, there is quite a rigid process that you need to follow that is a statutory process. So if any of your staff put in an official flexible working request, give us a call and we can talk you through what that process is. Or gov.uk or ACAS have both got step-by-step guides on how to deal with it. But if they just do it more informally, I would say have the conversation, decide on what you're going to do, and then I would be sending them a letter saying it's a contractual variation. And if it's just the hours, you wouldn't need to issue a new contract, just the variation letter that makes it clear that this part of their contract has been varied. Okay. An employee refuses to amend their working pattern. Can I make them? Now, this is the flip side of it, where you, on reopening, obviously you realise that you need to amend these working patterns and you've got an employee that refuses. So first port of call is to check the contracts, first of all, to see what their hours of work are and whether they are actually contractual or not, because that might give you some flexibility to force it. Do you have a variations clause? So look at your contract of employment and see whether or not you've got a variations clause. And if you do have a variations clause on which you can rely, would the change be reasonable? And I think I said this on the last one for any of you that attended, but there is no black and white list of what is reasonable and what is not reasonable when making changes to employment contracts. Arguably, if you're changing from 40 hours a week to 10 hours a week, then probably that would be seen to be unreasonable because it's a 75% drop. But if you're just taking 10% of hours off all staff across the board in order that you can carry on employing as many people as possible, there's a chance that that would be considered reasonable. And like I said, even if you do have a variations clause on which you can rely, it doesn't just give you carte blanche to make any changes you want. You need to consider people's personal circumstances a little bit when you're doing this. You know, for the most part, we generally advise that you should be consistent in treatment, but sometimes there is a need to make exceptions. So, for instance, if you've got a single mother and that's going to take her below a threshold to be able to claim a benefit, I don't know, just a hypothetical there for you, then it may be that that's considered to be sex discrimination. So if anybody is objecting, then I would be having a meeting with them to find out exactly why they're objecting, just so that you can ascertain what the risk factors are if you do decide to force the change through. You need to, and if they all object, then you would need to consult with them, and then technically what you do is you terminate and re-engage. And their recourse really would be that they decided that they didn't want the re-engagement, and so it would be an unfair dismissal claim. But let's be honest, the chance of them doing that is relatively slim, because everybody's going to be looking for jobs at the minute, and which is not a nice thing to think about, but it means that they're less likely to quit, because then they're going to have no job at all. And we're finding that a lot of employees are just kind of accepting it, because they kind of realize that having a job with less hours, for instance, is better than having no job whatsoever. Can I conduct interviews for new staff face-to-face? So we did have a lot of people who have made people redundant, a lot of our clients and yourselves in the BII. And now that they're looking at reopening, obviously they need to repopulate that staff base. So this is a regularly asked question. So yes, technically you can. However, at the moment, until you reopen, which I know is only kind of another few days, it would probably be a good idea to do them remotely still. If you would rather do it face-to-face, then what you need to do is you just need to ensure that all of your are in place, all your safety measures. And I would also recommend that you tell them before the interview what your safety measures are and what your expectations of them is, in terms of, do they need to wear a mask, you know, do they need to come to a specific door, anything like that, just so that they don't mess up, if only for them, you know, for their peace of mind, because they're likely to be nervous. Okay. So what should I put in any contracts for new staff that I take on regarding COVID? So this is something, again, we've been asked a lot about, whether or not there's any specific thing that they can put in, not only contracts, but policies as well, that will cover them in the event of COVID. Now, what we're saying is there are things that you can put in, but we wouldn't limit it to COVID. COVID is unique. And COVID, hopefully, you know, in the next year or two will no longer be an issue. But it might have flagged up things that maybe we didn't think about before, that can be put in a contract or a policy in a broader sense. So if there is another similar thing happen, which let's hope there isn't, it kind of gives you a little bit more flexibility as an employer. So let's have a think about what they might be. So like I said, nothing that you need to put in there solely for COVID. Let's think more broadly than that. So the biggest one that we found that people were wanting, is the layoff and the short-term working clause. Now, for those of you who don't know, broadly speaking, laying off employees means that the employer, you provide employees with no work and no pay other than a statutory pay for a period while retaining them as employees. And short-time working means providing employees with less work, so you're reducing their hours for a period while retaining them as employees. It's not a dismissal, and technically it's not even a contractual change. It's a temporary solution to the problem of no or less work. Now, this would help you in a very short-term way, but not long-term, the way that COVID has gone on and furlough was in place. And the reason for the layoffs and the short-time working is when you've got genuine issues that have happened, or, you know, maybe you're closed for a refurb, things like that. I'm not going to go into a lot of detail about what the provisions are about them, but what they do mean is if you lay somebody off for 6 weeks, or there's some parameters in there, then they actually then have the right to claim redundancy. So you should only really do it when you need to, but it is something that you can only do in actual fact if it's in your contract of employment, not even in a policy. It needs to be a contract. Now, we have double checked, and the ones on the BII contract builder, we have last year inserted the layoff and short-term working clause. So if you do use the BII contract builder, you have got the opportunity to do that. You can retrospectively, if you choose, try and add it kind of in as an additional clause, almost in the same way that you'd be changing a contract. It would be changing a contract in the same way as, you know, we previously talked about consulting with people. We do tend to find, though, that if you try and enforce this additional clause on your employees, you're going to get quite a lot of pushback, because what you're basically saying is, allow me to put something in there which means I can lay you off and not pay you. So for obvious reasons, employees are not really jumping up and down about it. So I'd show some caution about inserting it or trying to insert it into contracts of people that you already employ. But what you can do is, for anybody moving forward, you can make sure it's in there, and that's going to be a help from a short-term point of view. And have you got the appropriate contract? Now, a lot of businesses in the hospitality sector in particular obviously use 0 hours contracts or casual worker contracts. Unfortunately, a lot of them are used in the incorrect way. And so just because you give somebody a piece of paper that says this is a 0 hours contract, it doesn't necessarily mean that it is a 0 hours contract. 0 hours should only be used for people who are genuinely doing sporadic shifts. So, you know, like doing 1 or 2 shifts and then going away to university and then coming back and in the half term and what have you. If you've got anybody that works for you on a regular basis, sort of every week, and it doesn't necessarily need to be the same amount of hours every week, but just hours on a regular basis, then what happens is, from a legal point of view, that contract actually evolves into a regular employment contract. And so what you then find is that you're then having to treat those staff as if they were an employee. So what you might be better doing is actually, rather than putting them on 0 hours contracts, putting them on a regular employment contract, but just having a small amount of hours in there for your guaranteed hours. And I think a lot of people think that just because they're on 0 hours and so it automatically makes them 0 hours. If it were tested, a judge would look at what, not only the piece of paper, but what happens in practice. And in actual fact, especially if they've been employed by you for a while, that practice would probably supersede the contract. So it's important to make sure you've got them all on the appropriate contract, so that when you're looking at doing things in terms of their employment, the base on which you're starting is a good foundation. And again, have you got the appropriate amount of hours that reflect the practice rather than what you would like? Because that technically is what it would be deemed to be what happens in practice. What do I do if I don't want certain employees back? So we get this a lot, where people are wanting, you know, they realise they need to sort of decrease the staff base because there's going to be less hours to go around, and they want to be able to pick and choose which employees they want to bring back. And I completely get it, because you're going to want to choose your A-listers and not the ones that have messed you around. And I would say as well, the ones that have supported you during the furlough. You know, this has been a trying time for you as employers as well. If you've got people who've been trying hard to work for you and trying, you know, checking in with you, are you doing all right? Because your business is suffering, rather than just me, then, you know, I get it completely. However, just because that's what you want to do, it doesn't mean that legally that's what you can do. There are ways and means often, but you need to follow processes. So the first thing to do is to consider what the length of service is. If the people that you don't want back have got less than 2 years, that does make it a lot easier for you, because they don't have the right to claim unfair dismissal. So you could, in actual fact, just terminate them. And as long as you give them the notice and any accrued but outstanding holiday, there's not a great deal they can do. A couple of watch outs for this. There are a couple of things that you can claim for less than 2 years service. So discrimination is one of them. If they have protected characteristics, which are things like race, religion, sexual orientation, disability, then they can claim discrimination, especially if it's only one of them that you're getting rid of and they hold a protected characteristic, then they've been singled out. And if you don't give them a genuine reason, then the default would be that it's obviously because of their protected characteristics. So if any of the people that you are considering getting rid of who've got less than 2 years have got anything that stands out about them, anything that makes them in any way different, no matter how minor, give us a call and we can give you a risk assessment of that, depending on what it is. The other thing as well is it can be automatically unfair dismissal if they are dismissed for what's called a statutory right. And that encompasses a lot of things. So what you do need to show caution with is if somebody is saying health and safety at the minute is a big one. If they're saying, well, we're not coming back because it's not safe, you've not done this, you've not done that, don't just fire them to get rid of them, because you might not get rid of the problem, because technically you have the obligation to make sure that the health and safety is sound. And also they can then claim for automatic unfair dismissal based on the fact that they've raised a complaint about the health and safety. So it's not as clear cut as less than 2 years. For the most part, it's going to be very low risk, but always give us a tinkle about it. In fact, I'm just going to bring my colleague Keith in because he deals with a lot of our health and safety. If you could unmute yourself, Keith, wherever you are. What would you say that are things that they maybe need to consider when bringing staff back so that they can make sure that from a health and safety point of view, they're covered?
Yeah, thanks for that, Catherine. I hope you're all right, everyone. Yeah, I think the biggest thing at the moment when bringing people back is ensuring that you do have a COVID-19 risk assessment in place. You know, it's an employer's obligation to make sure that you protect your employees from harm. So having one of these in place is an absolute must at the moment. So, I mean, this includes identifying, you know, any working activities or situations that might, you know, transmit the virus. You have to think about who could be at risk and decide how likely someone could be exposed and what you're doing to control the risk, or in some cases, if you can actively remove any of those kind of situations. Once you have a risk assessment in place, it is vital to get all of your staff to read through it and understand it and, of course, sign it. There is some good guidance and some good templates on the HSC website, and what I will do is I'll put that in the chat so you all have access to that. But yeah, if you could all get that done straight away, it'll certainly help you all going forward.
And I believe there is Molly, you can probably confirm this, I believe there is some guidance from the BII as well, isn't there, for health and safety?
Yes, there is. Hi. I'm not sure if you can see me. I'm just typing into the chat now as well to make sure everyone's aware of it. We've got a helpline partner similar to yourselves at Bioni Law called Shield Safety Group. They offer a free risk assessment template and a helpline as well to back that up if you have any specific questions. But it's a really kind of simple template, so it will make you think about all the right areas, which you know you're already aware of, and for those of you who reopened last year at several points you will be aware of. But it's a really kind of good way to make sure you're covering off all of the points you need to be covering.
Brilliant. Thank you, Molly, and thanks, Keith. And you'll see why this is important. I'm going to move on to that a little bit later on in this, because we've actually, the geek in me is loving this, but we've had another case that's come out of the tribunal that is kind of based on COVID, and it's all about health and safety. So I'm just going to give you an overview of that, but not yet. I'm just teasing that. So if their length of service is greater than 2 years, then that's when you need to actually follow a process. Otherwise, you're potentially going to get stung for unfair dismissal. And like I said in the last one, when you're thinking about unfair dismissal claims, it's almost less about the reason that you dismissed them and more about the process that you followed, which would render that dismissal fair or unfair. So it's important that you follow an appropriate process, which while they're off, can be quite difficult. So to a degree, you might have to wait until they come back before you can do anything. So you need to consider why you don't want them back. Is it because of performance? Is it because of misconduct? Is it because of attitude? And obviously, if it's anything to do with that and they've got less than 2 years service, we can deal with that easily. If it's more than 2 years, these are the things, like I said, that you need to follow a process for. So if it's performance, it will be performance management process. If it's misconduct, you kind of need to wait for them to come back now, because arguably if they've been off for a while and they were behaving badly prior, it's probably, depending on when this act happened of misconduct, you've probably missed the boat, because you do have to jump on these things pretty quick. So it may be that you do need to allow them to come back and unfortunately mess up again, so that you can then discipline them for that. And if it's attitude, that's a really difficult one. It's always very difficult to manage attitudes, and that can sometimes come under performance, or it can sometimes come under misconduct. So it could be performance management or disciplinary, and that really depends on how that attitude is exhibited. Follow the proper procedure, whatever the reason it is. And I can't begin to to tell you that enough times. I'd tell you till you were blue in the face. We're here for a reason. You've got access to us. You can call us and ask for advice. And I would say that how many times I've lost count of where we've had somebody who's called us and they've got rid of somebody for the right reason because that person deserved to go, but they haven't followed the process and they've kind of phoned us afterwards. And we get it quite a lot where the claim's already started. And when you kind of go back and say, well, what procedure did you follow, so that we can give them the advice, to say, well, they did this, we thought it was gross misconduct, so we just dismissed them on the spot and that was it. And it's like, oh no. So because what will happen is, yeah, they probably deserve to get fired, but because you haven't followed the process, it would be an unfair dismissal. So if it got tested in a tribunal, they're likely to win, unfortunately. So before you do anything, always give us a call. And going back to that, the one thing I haven't put in there is redundancy. So the thing with redundancy is it's about the role, not the person. So for instance, if you've got bartenders and you've got 10 bartenders and you know that when you reopen, you're only going to do 5, you're only going to need 5. You can't just say, well, I want those 5 to be them. You need to include all 10 of them in the redundancy process and do what's called a selection criteria, a selection matrix. And that's done on objective things like disciplinary, attendance, things like that. So that you're not making a decision based on the person, you're making a decision based on objective data. But what I always say whenever I do redundancies, and unfortunately over the last 18 months, so we've done a lot, is you tend to find that the people that you don't want back are the people that tend to score the lowest in the selection criteria exercise anyway, because there's a reason you don't want them back. It's because they've been rubbish. And if they've been rubbish, their attendance is probably a bit shoddy and they may well have already had disciplinaries. So you do tend to find that those ones that are not the cream of the crop tend to end up on the bottom anyway. But if it is a reduction in headcount purely because of trade, redundancy is the way to go. Do I have to offer any staff that are made redundant before their jobs back if I need to hire more employees? I should have put a comma in there. The answer to that is no, you don't. You've got no obligation to. You should probably consider it if they were decent staff, as there'd be little training needed, and you could always invite them back on less hours on a contract or whatever than they were previously on. You wouldn't necessarily need to offer them exactly the same terms that they had in their contracts previously. How long is it since the redundancy happened? So what we usually say is if it's within the last 3 months, then you need to show some caution. And that isn't because there is a legally binding period of time before you can re-employ. That's an urban myth. There isn't one. There is nothing in law that says you cannot rehire after before a certain period has expired following a redundancy. A lot of people talk about 3 months, and the reason for that is that an employee who is being dismissed has 3 months minus a day to bring a claim for unfair dismissal in the employment tribunal. So if you make somebody redundant and then within 2 or 3 weeks you're already kind of advertising for that role, you're going to annoy them. They're going to be angry. And so you're more likely to prompt an unfair dismissal claim. So we usually recommend wait for a period of 3 months if you can, just so that it doesn't prompt a claim. Now, that doesn't necessarily mean that they'd be successful in a claim, but defending an unfair dismissal claim is not only a headache because there's a lot of paperwork that you need to do, but there's a lot of cost involved in terms of getting somebody to defend it for you, and also your time spent, because your time is a cost as well. So if you think that if you can hold off a little bit and wait till after that 3 months tactically, it's a good thing to do, because once that 3 months is gone, there's actually very little that they can do about it if they are aggrieved. But like I said, there is no definitive length of time. And when you're making a redundancy, it's done on the understanding that you're reacting to the business conditions at the time. And so it could very well be that you've made people redundant, and then within a month, suddenly Boris has made an announcement that, you know, vaccinations are all done, so we can reopen, and you can reopen fully, and you don't have to have any social distancing, and people can go to the bar. It's unlikely to happen, but, you know, you never know, fingers crossed. And in that respect, you might suddenly, and without realizing it, actually have an uptake in work, in which case you can actually rehire. So redundancies are not like you need to not rehire for ages. You need to react to your business conditions at the time that you're making your redundancies. But going back to that again, if you think it's a redundancy, give us a call, because there are some situations that it might appear to be a redundancy, but actually when you're sort of a bit more analytical about it, they're not. So we can give you some guidance on that. An employee is pregnant and refuses to come back to work. Can I make her, or does she have to isolate? So there's not a simple answer to this, and there are many things that need to be considered, and they need to be considered very carefully, because very few, when somebody is pregnant, she is basically the most protected that she'll ever be in her employment, and you need to show some massive caution when making any decisions about people within the workplace when they're pregnant. So you need to think about how far along is she. I think 28 weeks is the thing at the minute that they're saying if it's pre-28 weeks, then they don't necessarily need to be cautious. If it's post-28 weeks, that's when it's more high risk for them to be, exposed to COVID. What measures do you have in place? A lot of it might come down to your own health and safety. If the lady, for instance, is employed as a bookkeeper and she comes in when there are no customers in there, and she sits in an office and it's her own office, there's no other office, there'll be no other staff other than maybe the manager there. And so from a toilet facility point of view, she's fired, and it'll be just after the cleaners come. So, there'll be no cross-contamination. You could probably argue there's no reason for it to go off. But if she's a bartender and it's a busy place, for instance, then it might be that it's obviously going to be more difficult for you to sort of socially distance her. So you need to think about your measures in relation to her role. And can you ensure a safe working environment? That's really the crux of it. If you don't think you can ensure that you've got a safe working environment, or if she argues that you cannot provide it, you may need to think about placing her on suspension with full pay. And if you have other staff still furloughed, consider keeping her on furlough. However, I wouldn't just keep her on furlough if you've not got other staff furloughed, just in case there's discrimination there. So you could potentially place her on furlough and top it up, but what you don't want is for her to be a detriment due to a pregnancy. So if you've put her on furlough, she's only getting 80% of her wages and everybody else is back at work and they're obviously therefore getting 100%, then that detriment is the 20% decrease. What I would say though is have open conversations with them as much as you possibly can, because it may be, if she says, I'd like to stay on furlough and that's okay, and you're happy to do that, then that's fine because you've got her wanting to, but you just need to be careful if you're forcing it. Like I said, be very aware of discrimination. And you need to remember that some pregnant women are going to be super, super scared, which you can understand. They're growing a human in a very, with a virus going around that can be quite dangerous. But then other ladies, it may be that they're fine with it as long as you can show that you've got your measures in place. So it's about understanding what they're like as well. We've had some of our clients had pregnant ladies working up to their normal due dates, or when they were previously planning on going off, because they were fine with it. And the other thing I guess to consider is obviously pregnant ladies are being advised not to have the vaccine because the testing hasn't been done to understand how it can affect a pregnancy. So where everybody else may be vaccinated, your pregnant ladies won't be. Okay. An employee cannot return on their contractual hours because they've got a new dog. What do I do? And you might be laughing, but this is literally a call that we took. What, Ellie, was it about 2 days ago? Yeah, they've got a dog, so they can't come back to work. As an aside as well, this is my new favourite photo. We're big fans of dogs in our office. We went because we were able to now on an office walk on Sunday. So these are actually our dogs. We've got Chile, Reggie, Bridget and Teddy. And I look a bit like the dog whisperer there. And it's only because I've got a bag of treats in my hand. So we had a fun day on Sunday with all the dogs. So what do I do? And I would say most probably nothing. You're under no obligation to amend people's contractual hours because they got themselves a dog in lockdown. You might just need to wonder if they've got a disability, is the dog a service dog? In which case you might need to consider whether it would be a reasonable adjustment in order to do it. But let's be honest, it's a very, very slim chance that is the case. And if it's simply that they've acquired dog whilst working from home or on furlough, then it's not your responsibility to amend their working hours, and I'd tell them to get stuffed. That is my professional opinion. If I ask someone to return to work and they then are ill, do I need to leave them on furlough? So nope. You can if you choose to, but we are not recommending it. We're tending to find, and again, this has been a repeated conversation over the last week, that when people are saying, right, we're opening next Monday, so these are your shifts, suddenly, oh, well, I can't now because, you know, I've hurt my back or I've hurt my leg. And I think these employees think that they're going to be left on furlough. But I wouldn't do that. I would say that's absolutely fine. This is your first day of declared sickness, and I'm placing you now on sick leave. And your first 3 days will be unpaid because they're your waiting days, just to call a bit of bluff. So the purpose of furlough is that they are fit for work, and they're basically on call when they're on furlough for whenever you need them. So if they're sick, then they're not fit for work, are they? So it shouldn't be used for periods of short-term sickness. An exception was made for the clinically extremely vulnerable in order to shield without being at a detriment. However, shielding has now ended, so you don't even need to do that anymore. What I would say is, you know your staff, and you know whether they are genuine people who are genuinely ill, or whether they're people who are just quite happy to be sat at home on furlough. Now, anybody who's saying that they are ill, you should have a conversation with them, if not at the start, then at least on the return to work, asking what the sickness was, etc., etc. If you feel that they are genuinely ill, especially if they've got something that maybe is considered to be clinically extremely vulnerable, you know, they might previously have been shielding and still cautious about it, you might consider leaving them on furlough. But if it is the people who genuinely just don't want to come back to work because they're quite happy sat getting their 80%, I'd remove them from furlough, call their bluff, and place them on SSP or whatever your contract provides for. It may be that you give more. If someone goes off sick and it is not COVID related, so they get sick pay from day one. So no, that removal of the 3-day waiting period is only for COVID related sickness. All of the sickness is treated in the usual way. So you just need to revisit your sickness absence policy, and you need to follow that. What can I do if a member of staff is not following our H&S processes? So we get this again a lot, where, you know, we've got this in place, we've got that in place, but they're just not doing it. They don't understand it. They're just, you know, the staff are just not following what we're telling them to do. So I'd have a meeting with the individual, first of all, to set out the measures you have in place and find out why they're not fulfilling your expectations. So you need to have your risk assessment, which should have been sent to them all in the first instance anyway, but I would have another copy of it in this meeting, go through it all, explain to them why it's important and why you're doing it so that they fully understand, and then tell them what your expectations are. And I'd take notes during that meeting so that you can evidence that it's happened. If it is that they genuinely don't understand it or they need retraining on something, offer that support so that you can show that you have attempted to support them in that and you've attempted to make sure they are adhering to these processes. But again, like I said, ensure they understand their responsibilities, both what they are and why they're there. And I would then follow it up in writing. It doesn't necessarily need to be a formal letter. It can be in an email if you want, but it should basically be, we had a meeting then, this is what the meeting was about, this was what was discussed, this is why it's important, and this is what we expect you to do moving forward, just so that they can't say that they didn't know. And then a failure to then follow your processes after that could result in disciplinary action being taken, because it would be a failure to observe health and safety policies, putting your customers and their colleagues at risk, failure to follow a reasonable management instruction. There are a number of allegations that would come under. But what's important is, in order to make it a safe dismissal, if it did end in dismissal, depending on how serious it was, that meeting that you've had and then the follow-up is going to be your evidence to say, well, they knew what the expectations were and they still haven't done it. Okay. Follow your disciplinary policy. You are legally required to have a disciplinary policy in place in your business. If you haven't, the very minimum you should be your ACAS guidance. So I'd recommend following, going on ACAS website, having a look at their guidance if you're going to be doing a disciplinary, and or giving us a call. And in actual fact, I often recommend that people, the BII members, I often direct them to your ACAS disciplinary and grievance code of conduct, because it basically sets out for you step by step what you need to do, and it's also got all your template letters on there on ACAS as well. So this is the exciting bit, the geeking mate. So a new COVID related case, like I said, has come out of the tribunal. So The employee claimed automatic unfair dismissal under Section 100 of the Employment Rights Act. It's my favourite act, I think, of all of the acts. So Section 100 of the Employment Rights Act 96 says that if an employer dismisses someone for one of a number of reasons relating to health and safety, it will automatically be an unfair dismissal. Missed the B out there, didn't I? Which is what I was discussing with you earlier. Unlike ordinary unfair dismissal claims, though, there's no requirement to have 2 years service to bring this claim. So he had less than 2 years service and he was relying on Section 100 and relating to health and safety. So I'll give you an overview of what happened. The employee in question was working in quite a large warehouse, and we've read the employment tribunal transcripts. In fact, we read it earlier on today, didn't we, Ali? And both the claimant and the respondent and all the witnesses admitted that it's basically massive. It sounds like it's the size of a football field, basically. And there was himself and 4 other employees in this massive area. And it was at the time of the first lockdown in March. The reason it's only just coming out is because there's always a wait at the tribunal. So it was the actual tribunal was at the end of January of this year. So the employer announced that they were going to remain open and that they weren't going to close during the first lockdown, and they asked their employees to carry on coming to work. COVID safe measures were put in place in terms of reminding employees to socially distance, hand washing, additional cleaning, etc. Loads of stuff in place. And in actual fact, they'd actually taken advice from an external professional about these measures, which ties into what Molly was saying about you've got access to one of those on your BII, as part of your BII membership. The claimant left work as normal on the 27th of March and then texted his employer on the 29th to say that he would not be returning. He didn't really say why in a lot of detail. He basically said, I think it was something like until lockdown eases or something like that, that he would not be returning, but gave no reasonable timescale on that. He then made no further contact at all, and a few weeks later they dismissed him, and I think they dismissed him for unauthorised absence. And he then brought a claim of automatic unfair dismissal. So when you kind of listen to that, because he did not succeed, the judge found in the employer's favour, it says, well, brilliant. So that means that if someone just refuses to come to work, then I can just fire them. Not so, not necessarily. A few things that you need to think about. So the 2 specific sections of Section 100 that are relevant to this claim is the first one is that in circumstances of danger, the employee reasonably believed to be serious and imminent, they left work or did not return to work. And the second element of that was that in those same circumstances, he took reasonable steps to protect himself or other persons. Apologies for my use of being gender specific there. We usually try and stay gender neutral, but that's how it's written in legislation, because traditionally that's how it's written. So the judge felt that although the claimant did believe COVID-19 represented serious and imminent danger, this chap was clearly scared of COVID. And he had a young child at home that had got sickle cell anemia. He had another newborn, I think that was only a few months old. So he was kind of basing it on his fear of taking COVID home. And he felt that his home was the safest place that there was. And so basically, if nowhere else came up to scratch in terms of safety with his home, he wasn't going to go there. But the judge did not believe that there was a specific serious and imminent danger in the workplace. So the claimant acknowledged that it was not hard to socially distance in the workplace environment, and he also acknowledged that he'd been given advice about remaining safe. He hadn't brought to the boss's attention at any point that he felt that there were specific issues to do with safety. And when he informed his boss that he was not returning, he didn't say it was because of health and safety. He didn't give his employers the opportunity to rectify any issues that were there. And so the judge felt that his concern about the serious and imminent danger was a wider one. His concern was just about COVID, not because of COVID in his workplace. And so the judge therefore determined that the action of refusing to return to work was not an appropriate step to take, particularly where he had not raised concerns or made any effort to explore other options. And when you read the transcript of the employment tribunal, which we quite enjoyed, don't we, Ellie? You could see that this claimant, he kind of gave a few different versions of stories. And like on one hand, he was saying he wasn't going to go back because at first he said he'd got symptoms. And then it turned out that 2 days after he'd got symptoms and therefore should be isolating, which was after he'd already said that he couldn't come back because he was scared, he took his friend to hospital in a car. So he was saying that he was too scared to come back to work in his claim. However, he was happy to share a car with one of his friends who was going to hospital because he got symptoms of COVID. So there was quite a few discrepancies in this chap's story. So the points to take away from this tribunal is COVID-19 is capable of being circumstances of serious and imminent danger under Section 100. If somebody raises health and safety concerns, therefore, about what your measures are, then these protections should be considered to be relevant. So if you've got somebody who is bringing genuine concerns about the measures you have in place, you need to take that seriously, okay? And it doesn't mean that you can't then dismiss them if they still refuse to come in, but you need to show that you've taken every measure possible to make that workplace safe, and therefore they're being unreasonable. The judge felt that in order for this protection to kick in, as in the protection of Section 100, the concerns an employee has must be specific to the workplace. So they can't just say COVID, they need to say COVID in my employer's premises. The fact the workplace in question was objectively very safe was also really relevant. So the fact they'd got external help, the fact they'd got thorough risk assessments, the fact that they were being openly communicative with staff about what all those things were and what expectations were, really went in their favour, because they could show that they'd put everything in place that they possibly could, and that he had not raised any concerns that were ignored. So yeah, the fact the employee had not raised specific concerns about the failure to work was about workplace safety concerns was relevant to why his claim failed. And if a similar employee in a similar situation was more specific, as in I'm not coming back to work because, and I'm not going to come back to work until you rectify that, then the outcome might have been very different and the claimant might have actually won. So it's important to remember when we're looking at these judgments not to take them at face value. You really need to look at the detail of it to understand how that decision was come to. What did the judge take into account when they were making that decision? So what can you do? On the back of that, what can you do? So if somebody does come to you with concerns, you need to address it, being clear about that. Don't just poo-poo them, you need to address it. So you need to explore with them exactly what the nature of their concerns are. So sit them down, documented meeting, or do it remotely, which might be better if they're complaining about health and safety, and make them be specific. It can't be general. It's got to be, well, you know, I feel that we should be wearing face masks or shields and you're not providing with us the PPE, things like that. It can't just be general, I'm scared of COVID. Even if they are saying that, make sure you document it, because then you can back that up if you need to. And this will enable you to address with them any issues they might have, explain any measures that you have taken that will eradicate those issues that they're talking about. Or it might be that they've got genuine concerns about something that you haven't thought about, and you might actually say, thank you, I appreciate you bringing that to my attention, and we'll rectify that. Make sure you've got evidence of risk assessments or of COVID safe measures, and that these are being clearly communicated. And I would recommend that you do it via email, things like that, so that you can back up a paper trail if you need to. Try and understand someone's personal reasons for being concerned. Sometimes it's general anxiety, sometimes it's just that they're bullheaded. They might be worried about a vulnerable family member or a health condition that they themselves have. And then you can make a more educated decision as to whether or not you're going to do anything about their concerns. Also, consider alternatives. So even if you think that their concerns are not justified, let's not always jump to a dismissal. If there are alternatives to dismissing or disciplining for refusal to work, they should be explored. Could they work from home? Most of your staff can't, given the sector that you're in. Could they come in at different times to avoid busy public transport? So could you amend the duties? You know, do you need a cleaner? Could you say, right, well, I'll bring you in the morning so you can be a cleaner? Could their tasks be adjusted? consider all of this, and importantly, like I said, document it. Document everything, including, and most importantly, if you decide not to take any steps or not to change anything in your risk assessments or not to change anything in your working practices, document why you have made that decision, because that's going to be the crux of it. And if you can't change anything, you might want to consider agreeing a period of unpaid leave rather than taking the punitive action that a dismissal is. You know, you can say, fine, you know, you can not be at work if you want, but we feel that we've done everything we need to do. However, we understand you don't want to be here, but it'll be on the basis of unpaid leave, and that's your decision, employee. Okay. Oh, I forgot my last slide. I just went straight in. That's how excited I was about it. So we've already done all of that. Sorry. So now we're going to do questions. So I'm going to get rid of my presentation for you, because we don't need a presentation up on the screen. We just need Ellie's face. So I'm going to throw to Ellie. So have you had any questions, Ellie?
No, we haven't actually had any questions, which appears to be a bit of a pattern when I'm on.
So has anybody got any questions that they'd like to bring to us verbally now rather than putting in the chat? Oh, what was that? Was that in the chat, Ellie?
No.
All right, okay. No?
We're happy to answer anything.
Okay. Yeah, equally we're happy not to, and just go and get another cup of tea.
Yeah.
Brilliant. So if you do need to get in touch with us, I'm sure Marla, you can phone the BII helpline, and any advice that you need we can provide through that. If it's
is there a risk assessment on the BII website, a risk assessment template?
Yes, Tim, there is. I've put a link in the chat function on here, but if you go to our website, bii.org, if you can't see the chat function here, and you go to our coronavirus advice page, there's loads of information on there, and you'll find details of the Shield Safety Group risk assessment template. You will need to log in to get access to it as a member, but if you haven't got your login for any detail or for any reason, or you're having trouble, then you can just phone the team and they'll reset that for you, not a problem.
No, I've got it, that's fine, I can look at it then. Green King gave us their one, but I thought I'd look at the BII one as well.
Yeah, and I'm sure Green Kings will be very thorough as well. They'll have been through a similar process with a professional health and safety company as well, but it's always good to have several options and just read through the information that's available to you.
Yeah, you can never do too much in this circumstance when you're bringing staff back. And the thing with you guys is, you know, because you're open to the public, so you're going to get more staff that are trying to say that they don't want to come back for reasons of health and safety. It's not like you're in a closed environment like our office, for instance. You know, our office is that big and there's only a few of us in here, so we could literally be in different rooms to each other all day. I wouldn't even need to see your faces, would I, Ellie and Keith, if I chose not to? Sometimes I think they choose not to see my face, but I could choose not to see theirs as well, because our office is that big. Obviously, you're going to have members of the public coming into that you don't have any control over in terms of them. And so that's where your biggest risk factor is. So the more you can do in terms of evidencing things that you have put in place, measures that you've put in place, the better.
And you said earlier on, is it a specific part of the risk assessment for staff? Should I take a picture of it and send it to the staff before they come to work?
You should send the whole risk assessment to the staff, the whole thing, as a whole document. And as I said, I would email it to them all, because that way they can't ever say that they haven't seen it.
All right.
You can, or if they choose not to read it, then that's their problem. You've sent it to them, you've explained it all, you know, but you can evidence that they have had the opportunity to look at it.
Tim, also we've got on our website some downloadable checklists and posters that you can use around your venue. One of those checklists will be around staff logging in and making sure you know who they are, but we would also recommend, like Catherine said, to share everything with your staff. Don't keep them in the dark. Make sure that they are aware of absolutely everything that you're planning and you've put in place, because then not only do you protect yourself in terms of making sure you've proved that you've looked after them as well as customers, they can look after your customers better. Yeah, absolutely. Just, there's no reason to hide anything, because there's nothing in there that's business sensitive, is there? So don't hide it.
So as Ellie said, there have been a couple of questions, but somebody actually sent me one privately. Am I all right to just answer that one first, Ellie?
Yeah.
Just otherwise I might forget. So so the question I've had sent privately is, in terms of the pregnant person, you know, that we described earlier, the pregnant person, and can you force them to come into the workplace? If an employee lives with somebody that is shielding or vulnerable, what are your responsibilities as an employer? Technically none, because it's not your employee that is vulnerable. It is somebody that they live with, and it is their responsibility to make sure that when they re-enter their household, that they are safe. And at the start of the lockdown, the recommendations were that, you know, when you come home from work, get changed on the doorstep, lots of flashing to be had across the country at that point, you know, and discard all of your clothes before you go in so that you're not cross-contaminated. I think that's kind of the furore around that has kind of reduced quite a lot. But basically, you don't have any responsibility. If they do come to you and they are genuinely concerned, as I've said about a few other things, and you are considering leaving people on furlough and you think that they're being genuine, you may choose to do that, but you don't have to. And I shall pass over to Ellie.
Yeah, so we have actually just had a couple of questions being put in the chat, and they're the same sort of question. So I just thought we'd have a bit of a discussion about lateral flow tests, just as an open floor if anybody wants to ask anything further to what we discussed. But so the first question was from the Prince of Wales, and that was just said, what about the jabs? And I think you meant the lateral flow test, but I wasn't too sure what you're actually asking about the lateral flows. But then we have had a further question, just in terms of the difficulties in actually getting the free lateral flow tests, and whether we've seen the documentation and the hoops to jump through. Now, I've personally not seen the documentation. No. I don't know whether Catherine has.
No, we've not actually had to do it ourselves, and until you actually do it as a business.
We've had quite sort of close contact with the agency that's working with government to promote the lateral flow testing, because they were really keen to get that out to as many people as possible. They've obviously the deadline was last week, and I think they've now extended it to Monday. The one thing that we found, because we've got a lot of sole traders and you had to be a registered company to get access.
Oh, we lost Molly. I think we lost you there for a moment, Molly. Okay, so we appear to have lost Molly. So when Molly comes back, we can pick up on that. But what I guess from an employment point of view, Ellie, you could probably sort of discuss, can they force staff to take lateral flow tests? Do you want to pick that up?
Yeah, so in terms of, you know, actually forcing your staff to actually take the lateral flow tests, I think really, well, from my opinion, it comes down to sector specific sort of stuff in terms of what sector you're in, you know, the reasons why employees might not want to take them. I think it's perfectly reasonable for you as an employer to ask your employees to actually do the tests. In terms of forcing them, unfortunately, I don't think you can sit somebody down and shove something down the back of their throat or up the nose, because that would actually probably be more of a criminal matter than what it would an employment matter. But I think you're certainly within your rights to ask somebody to take it. Now, in terms of forcing them, I don't necessarily think it would be reasonable to actually force them to take it unless you had a genuine concern that they did have the virus, or there was somebody else in the workplace who had tested positive and you wanted to ensure your staff came back to work and all had negative tests, because they're working within the public environment and they are serving members of the public. So that could create a massive health and safety risk if you didn't know that all your staff were actually negative and serving members of the public. In terms of people's personal circumstances, so for example, if someone has a fear of putting something down the back of their throat and there was maybe a reason behind that, I would probably play a bit of caution towards those individuals who have specific needs and requests and reasons why they don't want to do it. But it's difficult to answer the hard and fast rule on whether or not you can force, because I think there's definitely a need to ask people to do the tests, but I don't necessarily think you can force it.
I think if it were tested, it would come down to how it was objectively justified.
Yeah.
Arguably in your trade, you're going to have more of a justification for doing it. And so really what you can't do is force them to. You can't pin somebody down. But what you could do is treat a refusal as a disciplinary offence. Now, what we do not have, because it has not happened yet, is any kind of precedent out of the employment tribunal system which dictates how judges are perceiving a forced test, because it's just too soon. None of them have been there for us to have a look. And even then, as you saw, you know, with the previous case that I told you about, it'll be taken on its own very specific circumstances. So I think if you are wanting to potentially look at forcing the lateral flow tests and you're not thinking about alternatives, that you're thinking about a dismissal, 100% give us a call first to look at the risk factor behind that, because we cannot tell you right now exactly how it will be treated, but we can probably give you a good take on whether or not your situation is potentially reasonable.
Molly's just had to pop off the chat because she said her internet was terrible, but what she has done is just coming back around to the actual flow test and whether or not you're a sole trader. She's actually put in a link in the chat, so anybody who is having a few problems with the tests, if you want to have a look at that link. I believe there's a bit of a problem with whether or not you're a large business or whether or not you're a small business, and how you actually get the tests. But if you have a look on that link, and if I'm being perfectly honest, I don't know whether Catherine has any other suggestions, but I think the best thing for you to do is actually have a look and see if there is a telephone number on the websites where you actually get the test from, and give them a call, because unfortunately, whilst we know about them, we don't actually know how to purchase them.
Yeah, it's related to employment in that businesses that employ people are able to do it, but it's not technically an employment matter. It's between you and the government really on how you get it. But yeah, we always recommend if there's a helpline, call the helpline, because you're more likely to get a response quicker than if you use email or anything like that. Claire, you put your hand up. It's like you're at school. You don't need to put your hand up. I'm not a teacher.
I've had a nightmare with these COVID things. I thought I would register. I'm a sole trader in my hospitality business, but I also have another business that's a limited company. So having to try and get the COVID, the link to get tests for me as a sole trader has been a nightmare. It hasn't happened yet. They're still waiting. And what they are suggesting is that for businesses which have 10 or less staff, that they are trying to put in place a system where you will register and your employees will receive their lateral flow tests at home. So you have to rely on the employees testing at home. The questions I raised with them were relating to their first position, which was, well, the employees are going to have to go off and get tested at a community centre twice a week if you want that to happen in your workplace. But that, of course, means what's the obligation on paying them? You're in their time, so you're going to be paying for them. We're in a rural situation, so you've got to pay for them to get there, to get back, maybe travel costs. So that's already adding into your base costs of opening again. It's too much. At the moment, having had this much documentation through, and there is a lot, and I've not even printed it all out, about getting these tests. I thought I'd made an order, and then I've heard absolutely nothing else for quite a few days. But I have a situation where I have 2 members of staff that have cancer. I have cancer as well, so I've been a vulnerable person, and they work at the front. And for their sake, for my sake, I want to make sure that my staff that come in have tested negative. So what is the situation do you suspect that might arise, or the risks?
I think it's so difficult, because what trumps the other? Because cancer is a disability. It is an automatic disability under the Equality Act. However, so are people also have human rights.
Yep.
And it is so difficult, Claire. I completely get it. And I don't think that anybody will be able to give you a definitive answer, because it hasn't yet been tested. What trumps what? The cancer, or whatever disability it is, the person with that vulnerability, or people's human rights to refuse what is an invasive test.
Do you think the right to life as a right supersedes, which is an absolute right, will supersede any other right, Article 8 rights about taking the test?
That's not something we can answer, especially because that's not within the employment law forum either, which is what our realms of expertise is. We literally just do employment. Human rights is an absolute beast, and it's likely that wouldn't even get answered unless it got to kind of Supreme Court.
Claire, what have your employees said? Have you actually had the discussion with them about potentially having the tests? And obviously, I know you can't. Employees might not want you to disclose their conditions, but I think in a situation like this, it might actually be worth just having an open and honest conversation with them and saying, look, this is what you need to do it.
The risk of coming to blows, because I have a lot of part-time staff. The ones that are vulnerable want to be able to come back and work. The ones that aren't vulnerable are a little bit more blasé about it. And that doesn't really sit comfortably with me as an employer.
Are the people who are suffering from cancer, are they happy for you to share that with the rest of the staff?
Yeah. Oh, it's common knowledge.
Yeah.
And the other staff are aware of it, but, they're sort of... I am at a point where I think I might be taking a view of saying that this is a requirement if you want to come back to work.
Well, I think
because it is so new that there's no precedence. There's not been tested anywhere, whether in the employment tribunal or whether it's in the High Court or the Supreme Court or the Hague or whatever. However high it goes up, there's nothing yet, and there's nothing in legislation for it because it's unique.
I think I'm concerned about is every tribunal seems to have about a 7 or 8 month waiting list as well.
More than that now. You're probably looking at about 18 months now.
Yeah.
So we're finding that just now, tribunal claims that were lodged start of last year are just starting to filter through. I think there's been probably about 3 or 4 decisions made in court based on COVID related things so far. And so in the coming months, there's going to be more and more. But this situation is so new because the lateral flow tests only happened in the last few weeks, that the ones that we're going to see coming out now are going to be related to issues that came up last March, April, not these ones. They're not going to go through quick enough. And it is so difficult. We completely appreciate it, but it's about being as open as you can with staff, and then making what needs to be an objectively justified decision on it. And there's nothing in law that is going to tell you what that objectively justified decision is.
Yeah. I think, like you said earlier on though, Catherine, I think if you had an open, honest discussion with your staff, but perhaps for the 2 individuals that are obviously clinically extremely vulnerable and will be more at risk, in terms of them as individuals, could they perhaps be provided with PPE equipment, which puts them less at risk? Could they be working shifts that are less, not as busy, so that could they actually be put on permanent like midday shifts? So could they be working 12 until 3 instead of, in the busier times when you're going to be open in the evening where you might be, quite a bit, or could they just work inside behind the bar?
Well, we're starting we're a rural pub, so basically we're only open in the evenings. It's not a big town place where you're going to find a lot of people going at any one time. So we're really dependent on the community supporting it, which means we have to support our staff. And we have great staff that are there that are vulnerable, but we respect that and we employ them. We don't discriminate. And then we have other staff that, as I said, are a little bit more blasé about it. But I find that when you put them together, where the risk is you're actually putting people in a situation where they feel that they are intimidated or threatened by the others as well. So it comes down actually to trying to avoid all of that, of having to make a decision. And I think at the moment I'm falling on the position of, well, we've got to make sure the staff are okay. We've got to make sure that the customers are okay. So anyone who's refusing to do this actually isn't supporting both of those aspects. What choice am I left with? And I think when you said, your colleague said earlier,
your choice is to potentially discipline, but what we can't tell you is whether that will be deemed to be fair or not.
I mean, it seems like one way you're going to hurt one party either way. You can't do it right. Then it's just
unfortunately. It's
yeah. It's I know it's so difficult. It's a damned if you do and you're damned if you don't kind of situation. But also the other thing that you need to think about is you're focusing on your staff here. What you can't control in terms of the people you've got with the disabilities is your clients, your customers.
Oh,
they're still going to be in contact with them, you know.
When I face on constructive dismissal claims from vulnerable staff members because they feel they don't want to work in those situations because they're working.
Well, yeah, but as long as you, when it comes to constructive unfair dismissal, they're very difficult claims to bring and indeed to win. And you would have to, they would have to prove that you had not done what you need to do as an employer. And you are.
Trying.
You know, so as long as you can say, this is what I have done, and I was in this difficult position, I needed to make this. And as long as you can justify it, you can back it all up, and there's a rationale there, probably it will be considered to be that they would lose, probably. And let's hope it doesn't get that far. I think our advice has to be at this point, have a discussion with the staff members who are not the disabled ones and explain why. You know, these people are suffering with cancer. They're going through a very difficult period. We really need your support with this. And this is a way that we can support them so that they can reintegrate into the workplace, reintegrate into society, because we all can't wait to reintegrate into bloody society, can we? We all just want to go for a pint, you know. And this is a way that they can do that. And, you know, just tug at their heartstrings a little bit. And what reasonable person really is going to say no?
We'll manipulate them and put them in a position where they can't say no then. Because
absolutely. There is, you know, I'm a massive advocate of manipulating staff as much as you can to get what you need out of them. That's what management is fundamentally. When you're managing staff, fundamentally, you are using your management techniques to manipulate your staff to get what you need out of them. So tug at their heartstrings, you know, you're going to kill this person with cancer if you don't do it. How would you feel about that? Would you be able to live with yourself? You know, and they'll probably all say, yeah, because who wants to kill someone? Not me. Yeah. You know, maybe that's maybe a bit extreme. I can be a bit extra about things. I don't do many things with moderation. So Ellie knows she has to sit next to me most days. So. But honestly, this, as long as you've got consent for those people who have got those conditions, openly tell them this is to protect your colleagues who are very vulnerable. And also, let's be honest with you, the way that the government is rattling on with these vaccines, which is one of the few things that they've done well, as soon as everybody is vaccinated, potentially it's going to be a moot point anyway. So in the next couple of months, it could be a non-issue.
Just on that point, if that's the case, what if you have staff that are refusing the vaccination?
I thought that question.
That's another kind of worms. Again, it's exactly the same. You can't force, you can't put someone down and jab them. You can't make them have the jab. What you can do potentially is dismiss as a refusal to. However, you need to take into account, are they refusing because of religious beliefs? Are they refusing because they've got underlying health conditions that could be considered to be a disability? In which case, if you dismiss them when they hold one of those protected characteristics, that would be discrimination. So there's no black and white. You need to take each individual situation on its own merits as to the why. But again, you need to be able to objectively justify it. And in actual fact, I think it'll be more difficult to justify firing someone for not having a vaccine than it would be for firing someone for not having a test. Because a test, yes, it's invasive, but once it's done, it's done. It doesn't leave anything inside you. But a vaccination is inserting something into your body, which is obviously a lot more serious. That's just my instinct. I've got nothing to base that on, but that's just what my instinct is. Would you agree, Ellie?
No, I agree with that. And I think you've got to consider not just like medical conditions, but I think you'd have to consider someone's personal anxieties and mental health. So, for example, if someone is, I don't know if there's a special term for being absolutely petrified of needles, but there could be a
needlephobic.
Maybe, and there could be a genuine anxiety over hating stuff like that. So just because you can't see it or they can't write their disability down on a piece of paper, if they had a genuine fear over that sort of stuff and it could be classed as a disability, I think you'd have to play it really carefully around that side of things. But
again,
see what people say.
Something else to remember is, if you've got somebody who's refusing to be vaccinated, let's be honest, we're near the end of the vaccination process for the first jabs. Very soon, it's them that are going to be at risk, not everybody else, because everyone else will be vaccinated. So in reality, they're only going to be putting themselves at risk. So that's up to them. That's the way I see it anyway.
Yeah.
Do you there'd be issues in asking potential employees on interview if they've been vaccinated or not?
So that would be more safe in terms of a decision made on employment. Dismissing somebody than just not employing somebody. So you could say, I will only employ vaccinated people. However, you do need to make it clear that you would make exceptions for anybody holding a protected characteristic. So if it's medical or if it's religious, you might have to make that exception, because that could be discrimination. But if somebody doesn't hold a protected characteristic, like it would only be the same thing as I'm not employing you because you got tattoos.
Yeah.
It falls into one of the pigeonholes to characteristic, and it's that's the reason that
I think Catherine's internet might have just gone slightly, but yeah, what she's sort of saying there is, you know, I think it's perfectly fine to ask the question on interview. It doesn't mean that the decision to employ that person is going to be solely based around that particular question, but it certainly gives, you know, food for thought, and it might make you think twice, especially if you're between two candidates, one who's really popular, you know, a really good candidate, one who's not a really good candidate, and the only difference would be that one's vaccinated and one's not. That would be sort of the difference in that. But so I think Catherine's back now, but she's on mute.
all right. I think Ali finished answering your question there, didn't she? Tag teaming it, weren't we, Ali? Okay, so does anybody else have any more questions at all that you would like answering while we're here? We've got about another 5 minutes before we've got to go into our next one.